Shalom, this is your Ark. Yah is magnified, coming back with another informative video. I titled this video, Will Gary Lynn Scott Jr. have a trial before a federal court? Part 4, the conclusion of the matter. But before I tackle this subject, as always, I must state for the record, I'm not a lawyer, I do not practice law, and I do not pretend to. All my videos are for informational and educational purposes only. They're all facts and all truth, nothing more, nothing less. So with that being said, guys, let's get to it. Okay, so now as you all know, this is actually the 5th video in a 4-part series, okay? So if you all haven't watched part 1 through 3.5, then pause this video, go back and watch part 1 through video 3.5, and then come back here and watch part 4, okay? Alright, so let's continue on for those who did watch all the prior 4 videos before this video. Okay, so those who watched the video, for a quick rundown, you all know that me and Gary Lynn Scott Jr. had gotten into it in a Facebook group because I was basically telling him his outcome before it happened. Okay, Gary Lynn Scott Jr. couldn't take the truth, so then he started getting very disrespectful. But not only did he get very disrespectful, he went to the person channel who helped him with this case, and then they both got very disrespectful because they know, like I know, that everything I was saying was the truth. But Gary Lynn Scott didn't want to accept the truth himself. Okay, so I told him, since he did that, I will make a video about his case, and I will show everyone the outcome of that case. Okay, this video is not just to bash Gary Lynn Scott Jr. No, it's not. This video is to tell you all that it's the same story. Okay, stop trying to sue these people in federal court. Okay, you're not going to receive monetary damages suing these people in federal court. You must follow the rules of etiquette, or should I say the rules of civil procedures. Meaning what? You must go up to chambers in state court. Okay, and after you leave state Supreme Court, then you can file your motion and your documents into federal Supreme Court. Then and only then, because the lower federal courts cannot hear family law issues. Okay, like I explained multiple times. So I'm just keeping my promise, like I told Gary Lynn Scott Jr., when he lose, I will be the first one to say, I told you so. Okay? And that's all this is, man. I told you so. Pay attention, man. Seek remedy in the state. Stop listening to these other cats. You know, you haven't came back on that channel and issued an apology to me. Why? Because everything I told you was going to happen. And because you didn't do that, and that channel haven't brought you back on this channel to explain what happened to you. No, they're trying to push it under the rug. But I'm bringing everything back out. So after Gary Lynn Scott Jr. case, James Williams case, you're next. Because you came on that same channel and was very disrespectful as well. So like I tell you all, man, the truth will be the truth. So let's go over this document. As you all can see, this was done in the United States District Court, Eastern District of Tennessee, Chattanooga Division, right? Same plaintiff, Gary Lynn Scott Jr. versus what? The Child Support Program et al. Case number and everything. Let's pick this up at the top. Memorandum and order. This matters before the court on the defendant's numerous motions to dismiss. Docket number 49, 51, 53, 58, 60. And plaintiff motion to dismiss, defendant's motion to dismiss, docket 66, which the court construes as a response to the defendant's motion to dismiss. For reasons stated below, the court will grant defendant's motion to dismiss, docket 49, 51, 53, 58, 60, and deny plaintiff's motion to dismiss the motion to dismiss. Okay, so now, just by reading that alone, the defendant motion to dismiss was granted, which is the Child Support Program, right? It was granted, okay? And the plaintiff motion to dismiss, Gary Lynn Scott Jr., was denied. So right there is evidence that the case is over with. It's done, it's over with, it's a done deal. Okay? Gary Lynn Scott Jr. lost his federal lawsuit like I told him he was. Okay? I hate to be the bearer of bad news, but the truth will set you free. People need to accept the truth and learn from it and pick themselves up and dust themselves off and go back in there now and do things the right way. I was once here. I lost in federal court too, dealing with certain people. And the same person he dealt with, I dealt with. And it's just that simple. But let's continue the background. 1. Background. In his amended complaint, plaintiff states that he seeks to bring an action pursuant to what? 42 U.S.C. subsection 1983. I told y'all to stop filing those type of claims in federal court against the agency. Okay? Why? They have this part covered. But let's continue. For deprivation of his rights by 45 CFR subsection 75.2, contractors masquerading as state and local officials. Document 40-1 at 3. Plaintiff contends that jurisdiction is proper because his complaint raises questions of federal constitutional law. ID at 5. Plaintiff asserts that defendants certified that the current 4D case was established in compliance with the with Title 4D of the Social Security Act. However, the title, let's go to the next page, containing Section 4D has never been enacted into positive law, and therefore 4D provisions are not law. Okay? We know who teaches that, but let's continue forward. It states, plaintiff states that the events given rise to his claim occurred at the Hamilton County Circuit Court. Plaintiff alleges that in 1997, the clerk of court sold him a marriage license, but failed to inform him that by applying for said license, if the marriage failed and offspring was born from the marriage, he would by default become liable for the debt to the child support program. Plaintiff alleges that under the Fifth Amendment, the clerk of court was required to inform him of his consequences orally, through audio or video equipment, and in writing, before he signed the marriage license. In 2009, plaintiff was divorced and alleged that he was then fraudulently induced under threat, duress, and coercion by 45 CFR subsection 75.2 contractor W. Neil Thomas to sign a parenting plan to which he was deprived of his rights to due process pertaining to the legal consequences that arise from signing the contract. In 2017, plaintiff attended a 4D modification hearing under threat, duress, and coercion, and at that hearing refused to sign the contract offer because he did not agree to the terms and conditions. However, plaintiff alleges that his attorney signed the contract despite having no authority to do so, right? Let's go to the next page. That's page 2. Let's pick this up at page 3. Plaintiff further alleges that the defendants entered into a contract with OCSE to offer and sell 4D services in return for a share of billions in federal profits. Plaintiff essentially alleges that the child support program is a private for-profit business that offers and sells 4D services. As his injury, plaintiff alleges that state and federal law did do major damage to clear and substantial federal interests, and he can now demand intervention in federal court. Plaintiff states that the following constitutional violations occurred. 1. Inflation of a bill of attainder in violation of Article 1, Section 9, Paragraph 3. 2. Compelled association in violation of the First Amendment. 3. Violation of the rights to be secured and to privacy under the Fourth Amendment. 4. Violation of the Fifth Amendment rights against double jeopardy and self-incrimination and providing for due process. 5. Denial of a trial by jury and the rights to counsel in violation of the Sixth Amendment. 6. Involuntary servitude in violation of the 13th Amendment. And 7. Denials of due process and equal protection in violation of the 14th Amendment. Scott also states that he is bringing claims for fraudulent inducement, fraud, dissemination of false advertisement, compelled use of Social Security number, and peonage. As relief, plaintiff asks the court to 1. Terminate the current private for-profit contractual enforcement 4D case effective immediately. Right? Then it states 2. Enter judgment in his favor for a full refund of $80,000 as well as for various amounts of profit and interest. 3. Award punitive damages of $1 million to each defendant. 4. Reverse all negative credit reports. And 5. Order all defendants to issue a letter of apology. That's page 3, guys. Let's pick this up at page 4. Let's continue on. Each named defendant has filed a motion to dismiss, arguing inter alia that the court lacks jurisdiction over this matter. Plaintiff has failed to properly effectuate service of process, and the complaint fails to state a claim for which relief can be granted. Document 49 through 53, 58 through 62, and 69. Then it states plaintiff response with a motion to dismiss the defendant's motion to dismiss, in which he reiterates the argument from his complaint, contends that he does not want or need for these services to provide for his children, and spends sufficient time explaining why defendants are contractors. However, plaintiff does not address any of the substantive arguments raised by defendants in their motion to dismiss. The court construes this filing as a response to the defendant's motion to dismiss. 2. Standard of review. Let's continue on, guys. Federal courts are courts of limited jurisdiction. Case law to support that. In other words, federal courts have only powers that is authorized by Article 3 of the United States Constitution, and that statutes enacted by Congress pursuant thereto. Case law to support that. As such, subject matter jurisdiction is a threshold issue that the court must address and resolve prior to reaching the merits of the case. Case law to support that, and Federal Rules of Civil Procedure 12H3, providing that if the court determines at any time that it lacks subject matter jurisdiction, the court must dismiss the action. Unlike a motion to dismiss for failure to state a claim under Rule 12b-6, where subject matter jurisdiction is challenged under Rule 12b-1, plaintiff has the burden of proving jurisdiction in order to survive the motion, right? So now let's pick this up at page 5. Let's continue on. Like I stated before, they're doing what? 12b-1 and 12b-6. Why? Because federal courts cannot hear these type of claims. But let's continue. Rule 12b-1. Motion falls into two categories: facial attacks and factual attacks. Case law to support that. Let's continue. A facial attack is a challenge to the sufficiency of the pleading itself. In considering whether jurisdiction has been established on the face of the pleading, the court must take the material allegations of the pleading as true and construed in light most favorable of the non-moving party. Case law to support that. A factual attack, on the other hand, is not a challenge of the sufficiency of the pleading allegations, but a challenge to the factual existence of subject matter jurisdiction. Pursuant to Rule 12b-6 of the Federal Rules of Civil Procedures, a complaint may be dismissed for failure to state a claim if a plaintiff fails to proffer enough facts to state a claim to relief that is plausible on its face. Case law to support that. When considering a Rule 12b-6 motion, a court must treat all the well-pleaded allegations of the complaint as true and construe all the allegations in the light most favorable to the non-moving party. More case law to support that. However, the court need not to accept as true legal conclusions or unwarranted factual inferences and conclusionary allegations, or legal conclusions masquerading as factual allegations will not suffice. So now, as you all can see, like I tell you all, you just can't go to court making these conclusionary statements without any factual evidence to support those statements that you are just throwing out there, okay? You must support all allegations with evidence to prove your point. You know, just don't go in there saying, well, they doing this, they doing that, this happened, that happened, without any evidence of any of that happening, okay? But let's continue. Case law to support that. Then it states, dismissal under Rule 12b-6 is proper when there is no set of facts that would allow the plaintiff to recover, okay? Case law to support that. But let's continue to page 6. We have more case law to support that. Let's pick it up at the top. To survive a motion to dismiss under Rule 12b-6, a complaint must contain either direct or inferential allegations respecting all the material elements to sustain a recovery under some valuable legal theory. Right? Let's pick this up at number 3. Discussions. A. Jurisdiction. Subject matter jurisdiction is always a threshold determination. Case law to support that. If the court determines at any time that it lacks subject matter jurisdiction, the court must dismiss the action. Federal Rules of Civil Procedures 12H3. Generally, federal courts lack jurisdiction over domestic relation matters because state courts have exclusive jurisdiction over these matters. Like I tell you all over and over and over again, state courts have exclusive jurisdiction over all domestic relation issues. So why you guys continue to try to file a federal lawsuit in these federal courts? It beats me, man. You know, like I tell y'all, get that right wisdom, that right knowledge, and that right understanding. But let's continue. Although this exception to federal jurisdiction does not apply to a civil action that merely has domestic relation overtones, federal courts lack jurisdiction where the action is a mere pretense and that the suit is actually concerned with domestic relation issues. Okay? More case law to support that. Let's continue. Moreover, federal courts lack jurisdiction to review a case litigated and decided in state courts because only the United States Supreme Court has jurisdiction to correct state court judgments. Like I said earlier in the video, guys, the United States Supreme Court is the only court that can correct state court judgments. That's it. That's all. But let's continue. Typically, the federal courts refrain from entering domestic relation cases, even when brought under the guise of a federal question action. A suit whose substance is domestic relations generally will not be entertained in a federal court. Case law to support that. Further, the Supreme Court has found that the whole subject of the domestic relations of husband and wife, parent and child belongs to, we on page 7 now, the laws of the state and not the laws of the United States. Let's continue. Because state courts historically have decided these matters, they have developed a proficiency and expertise in these cases and a strong interest in disposing of them. Right? Let's continue. More case law to support that. However, the Sixth Circuit has clarified that the domestic relations exceptions applies only to a narrow range of circumstances and does not deprive federal courts of jurisdiction to adjudicate a claim unless a plaintiff positively sues in federal court for divorce, alimony, or child custody, or seeks to modify or interpret an existing divorce, alimony, or child custody decree. But all that must be done first what? In federal court. It must start in federal court and end in federal court. Okay? Not starting in state court and then took to federal court. No, got to be started in federal court and end in federal court. But let's continue for those particular situations. But let's continue. More case law to support that. The domestic relations exception does not apply when a plaintiff requests that the federal court apply federal law to determine whether official conspired against him in the course of administering a child support program. Because this inquiry does not require application of state child custody law, questions of state calculation of child support payments, or otherwise addresses the merits of the underlying dispute. Accordingly, the fact that the alleged violation of federal law occurred in the course of deciding a plaintiff's child support obligation does not invoke the domestic relations exception. Okay, guys, but let's continue. The ultimate inquiry in determining the applicability of the domestic relations exception focus on the remedy that the plaintiff seeks. Does the plaintiff seek an issuance of modification or enforcement of a divorce, alimony, or child custody decree? Case law to support that. Now we're on page 8. Let's pick this up at the top. The court concludes that it lacks jurisdiction over this matter based on the domestic relations exception. Although plaintiff purports to raise various questions of federal constitutional law, the court finds that these arguments are mere pretense for seeking review of domestic relation matters. In making this determination, the court notes that the allegations and claims in plaintiff amended complaints are largely unintelligible assertions which appear to be based on the common sovereign citizen belief that federal government is a corporation. Courts around the country have routinely rejected these frivolous arguments. So as you all can see, basically the judge is calling Gary Lynn Scott Jr. Complaint frivolous and sovereign citizen arguments. But let's continue. Indeed, this court has recognized that sovereign citizen pleadings are dense, complex, and virtually unreadable, and a branch of sovereign citizen case laws has grown to address the voluminous and often frivolous workload. More case law to support that. Let's continue. Because plaintiff claims are to be based on these frivolous sovereign citizen arguments, the court concludes that plaintiff alleged federal claims are mere pretense to seek review of the state child support order. Let's continue. In making this decision, the court also finds instructive the relief that plaintiff seeks, overturning the state's court child support order and return of past child support payments. Such relief is the classic type sought in a case that falls within the domestic relations exceptions. Accordingly, the court concludes that it lacks jurisdiction over this matter. Now we're on page 9. Let's pick this up at the top. Based on the domestic relations exception, the defendant motion to dismiss docs 49, 51, 53, 58, 60 are granted on this ground. B. Statute of limitations. Federal District Court applies state statute of limitations in proceedings brought under 42 U.S.C. subsection 1983. Case law to support that. Although subsection 1983 has no statute of limitation on its own, the applicable limitation period is the same period that state law provides for personal injury torts, which is 1 year in Tennessee. Okay, more case law to support that. Let's continue. Under the discovery rule, a statute of limitation begins to run from the time when a plaintiff discovers or in the exercise of reasonable care and diligence should have discovered his injury and the cause thereof. Case law to support that. Thus, in Tennessee, a cause of action accrues and the statute of limitation begins to run not only when the plaintiff has actual knowledge of a claim, but also when the plaintiff has actual knowledge of facts sufficient to put a reasonable person on notice that he or she has suffered an injury as a result of a wrongful conduct, right? More case law to support that. Let's continue on. By plaintiff's own admission, the dates that give rise to his claims are May 2009, August 2017 to current. Doc 41 at 6. A review of the full docket in this case indicates that plaintiff's first child support order was entered after his divorce in May 2009, and the child support order was amended in August 2017. Plaintiff's filings also made clear that plaintiff knew about these child support orders at the time when they were entered. Accordingly, by his own admission, plaintiff knew of the latest events giving rise to his claims in August 2017, yet did not file his initial complaint until November 13, 2018, docket number 1, after the 1 year limitation period had expired. Because even reviewing the allegations in light most favorable to the plaintiff, his claims are barred by 1 year statute of limitations. Defendant motion to dismiss docs 49, 51, 53, 58, 60 are granted on this alternative ground. Okay, but let's continue. Let's pick this up at 4. The court acknowledges that defendant have raised numerous other grounds for dismissal. However, in light of the conclusions above and the utter frivolity of plaintiff's amended complaint, the court will not waste judicial time and resources addressing each ground. For the 2 alternative reasons discussed above, defendant motion to dismiss doc 49, 51, 53, 58, 60 are granted, and plaintiff's motion to dismiss, defendant's motion to dismiss, doc 66 is denied. This matter is dismissed. The remaining pending motion, docs 73, 76, and 81, which relate to summary judgment, are denied as moot. The clerk of court is directed to close this case. It is so ordered. Leon Jordan, United States District Judge. So again, guys, this is the conclusion of the matter. Like I told you all, man, started these federal courts. I cannot stress this enough. To the brother Gary Lynn Scott Jr., I told you when you lose, I will be the first person to come back on here and tell you that I told you so. And it's just that simple, man. You know, now you got to go back on that person's channel and let everybody know what happened. And it's just that simple. But that's all I'm going to do for today, guys. Again, another one bites the dust in federal court. So start these federal courts. Get your remedy in state. All right. So you all be blessed. Enjoy your day. If you all need my help, hit me up at my email at y'allismagnified@gmail.com. Like, share, and subscribe. Much love. You know, peace to everybody out there. And with that being said, I say shalom.